I don't understand why the Jeffrey Epstein case would be of interest to anybody. It's pretty boring stuff.
Millions of pages of investigative material tied to the late financier Jeffrey Epstein have finally been made public by the USA Department of Justice under a federal transparency law signed by Donald Trump in late 2025. According to public reporting, the unprecedented release includes over 3 million pages, thousands of images and videos, yet critics from both sides of the political aisle blasted the rollout as incomplete, heavily redacted, and legally rushed. Former President Trump has publicly defended the disclosures, while his allies and critics alike accuse the DOJ of either shielding powerful figures or mishandling victims' privacy. As fresh controversy spreads, this isn't just about old documents, it's a clash between institutional process and political calculation. According to public reporting and federal records, the controversy now labeled the Epstein files began decades earlier with the criminal investigations of financier Jeffrey Epstein for sex trafficking of minors. Epstein's 2019 death in custody left a trove of investigative materials in the hands of the Department of Justice and the FBI. During the 2024 presidential campaign, Donald Trump and his allies repeatedly promised to make additional Epstein records public, portraying the files as a matter of accountability. At the time, Trump emphasized transparency, while critics warned against politicizing law enforcement records. In November 2025, Congress passed and Trump signed the Epstein Files Transparency Act, a federal law requiring the Justice Department to release all unclassified documents and related materials connected to Epstein's prosecutions and investigations within 30 days. When the December 19 deadline came, however, the department had released only a fraction of the material. According to public reports, DOJ officials said the backlog and legal privacy obligations, especially the shielding of victim identities, made the full publication slower and more complex than anticipated. Critics from both parties argued that the delays amounted to resistance within the institution to full disclosure. Trump publicly pushed back against criticism, framing the delays and ongoing release process as either exaggerated or unfair. Press reports noted he and close allies characterized the Epstein files issue as a political cudgel rather than a legal compliance matter. Institutional constraints were clear. DOJ and FBI officials stressed that the law did not create penalties for non-compliance, and that the department had to balance victim protections, attorney-client privileges, and privilege rules with the mandate to publish records. Many files were heavily redacted under established legal standards. As millions of pages rolled out in early 2026, the clash shifted from questions about whether documents should be released to debates over how and when, and to what extent Trump's political posture shaped perceptions of the process. The controversy was no longer just about Epstein, it was about the limits of executive influence over independent legal procedures. The political storm promised to deepen as more people reviewed the material. Press reports indicated both victims' advocates and lawmakers continued to call for more transparency, a pressure point that Trump's public messaging could not fully extinguish. The Epstein Files Transparency Act was drafted and passed by Congress with overwhelming bipartisan support in November 2025. Signed by Trump, the law required the Attorney General to make publicly available all unclassified Department of Justice material related to Epstein's investigations and prosecutions within a strict 30-day timeline. It also mandated provision of an unredacted list of government officials and politically exposed persons mentioned in the files. This legal framework placed Trump in a complicated institutional position. The act laid out what should be released and when, but it did not create enforcement mechanisms or penalties for failure to meet the deadline. Nor did it grant the president direct authority to override redaction rules or privacy protections embedded in long-standing DOJ policy and federal privacy law. According to official DOJ press statements, Deputy Attorney General Todd Blanche led a large review process that ultimately resulted in the release of over 3.5 million pages of material by late January 2026. The files included more than 2,000 videos and 180,000 images drawn from multiple investigative streams, ranging from the original Florida and New York cases to FBI inquiries and Maxwell prosecutions. The department involved hundreds of attorneys and reviewers tasked with balancing the mandate to publish with strictly protecting victim identities and complying with attorney-client privilege and deliberative process privilege. Many documents that could not legally be released, including child pornography or privileged communications, were withheld. From an institutional standpoint, this process underscored the limits of political direction. The DOJ, as a career civil service institution, follows statutory and procedural law rather than presidential preference. While Trump signed the transparency law, he could not determine how cases were reviewed or how redaction decisions were executed. When the files were finally made available, press reports noted extensive redaction, sporadic organization, and dozens of references to public figures, including mentions or unverified submissions that incidentally included the name of Trump or closely associated individuals. Importantly, being named in files does not establish wrongdoing and has been explicitly noted by DOJ officials and reporters alike. Lawmakers and survivors publicly criticized the department for failing to meet the statutory deadline and for how the redactions were carried out. Several advocacy groups and congressional figures contended that the process fell short of the law's intent, fueling ongoing political tension. Across the political spectrum, the legal release sparked clear institutional pushback from those who argue that procedural integrity was compromised and from those who argue the release was too limited. Both types of criticism highlighted the clash between legal obligations and political narratives, a clash that Trump's messaging had inadvertently intensified. Despite the rollout of millions of pages, questions about completeness and compliance lingered. Institutional constraints within the DOJ and the interpretive latitude afforded to federal reviewers meant that even under a law bearing the president's signature, the final outcome could diverge significantly from the expectations set by political actors. The release did not settle the matter. It reopened scrutiny, and it showed how a presidential decision, once institutionalized into law, can evolve beyond immediate political control. By the time the Epstein files entered broad public circulation in early 2026, the conflict surrounding them was no longer primarily about disclosure. It had become a test of power boundaries. According to public reporting and official documents, Donald Trump's posture shifted from championing transparency to disputing the legitimacy, speed, and framing of the very process his administration had helped formalize. That shift marked the central climax of this story. Trump's original political promise had been straightforward: expose what institutions had hidden. Yet once the Epstein Files Transparency Act became law, that promise transformed into a legal obligation governed by procedures Trump no longer controlled. The miscalculation was structural. Trump appeared to assume that because he had signed the law, he would retain influence over its execution. Court filings and DOJ statements show otherwise. From the moment the statute took effect, authority moved into the hands of career officials, federal judges, and statutory review mechanisms. This is where the pressure intensified. According to public reporting, Trump publicly framed the DOJ's pace and redaction practices as evidence of institutional resistance or selective transparency. But legally, the DOJ was operating within well-established constraints. Federal law requires the protection of victim identities, limits disclosure of sealed or privileged material, and mandates careful review of evidence gathered in sex trafficking investigations. These rules did not originate with Epstein. They predated Trump, and they could not be bypassed by political will. The DOJ's response was not confrontational. According to official statements, department leaders emphasized compliance rather than debate. They pointed to the sheer scale of the material, the involvement of multiple investigative streams, and the obligation to ensure that disclosure did not re-traumatize victims or compromise unrelated legal matters. This procedural language stood in sharp contrast to Trump's political framing, which emphasized urgency and exposure. At the heart of the climax was a collision of timelines. Trump operated on political time measured in headlines, reactions, and public perception. The DOJ operated on legal time measured in statutory deadlines, review stages, and judicial oversight. These timelines did not intersect. Each additional document release underscored that reality. Trump responded after each tranche, while the institution continued forward without adjustment. According to public reporting, this dynamic exposed a second blind spot. Trump's messaging suggested that naming individuals in files implied culpability. Yet, DOJ officials and legal analysts repeatedly stressed that inclusion in investigative records does not equate to criminal liability. The Epstein files included raw material, tips, contacts, flight logs, interview notes, and unverified statements. These records were never intended to function as verdicts. Treating them as such blurred the line between documentation and adjudication. When Trump himself was mentioned in renewed coverage, he relied on that distinction to defend against insinuation. He acknowledged prior social contact with Epstein as he had before, while denying any wrongdoing. That response mirrored the DOJ's own cautions about interpretation. Yet the symmetry revealed the trap Trump faced. He could not simultaneously argue that the files exposed wrongdoing while insisting that mentions were meaningless when applied to him. The contradiction weakened his broader narrative. The institutional response remained consistent. According to public reporting, the DOJ clarified that the release did not reopen investigations and was not designed to generate new prosecutions. It was archival compliance, not prosecutorial escalation. That clarification narrowed Trump's remaining angles of attack. Without new charges, there was no legal outcome to challenge. Without procedural violations, there was no basis for intervention. As scrutiny intensified, commentators began focusing less on Epstein and more on governance. Legal scholars noted that the episode illustrated a recurring feature of American institutions. Once a process is codified into law, it resists personalization. Trump's influence had been decisive at the moment of enactment. Afterward, it dissolved into structure. According to public reporting, this observation gained traction across ideological lines. Trump attempted to reframe the conflict as part of a broader critique of the DOJ, aligning it with claims of institutional bias and weaponization. But the Epstein files posed a problem for that argument. The release was compelled by statute, overseen by courts, and executed through routine compliance mechanisms. There was no discretionary trigger that could be plausibly characterized as targeted action. The climax deepened as Trump's criticisms failed to produce institutional reaction. The DOJ did not accelerate or slow releases in response. Courts did not intervene. Congress did not amend the statute. The system absorbed the pressure without visible strain. Trump's posture increasingly resembled that of an external critic rather than an executive authority. This asymmetry carried consequences. According to public reporting, Trump's repeated objections began to sound circular. Each statement restated grievance without altering outcome. Meanwhile, the DOJ's silence became its own message. Procedure would not bend to rhetoric. That silence deprived Trump of escalation pathways. There was no adversarial exchange to sustain momentum. At this point, the Epstein files ceased to function as a live controversy and became a structural case study. They demonstrated how political initiatives, once translated into law, acquire inertia independent of their sponsors. Trump's role shifted from initiator to respondent. His leverage narrowed accordingly. The climax was not marked by a revelation or a confrontation, but by stabilization. The DOJ completed its releases. The courts maintained oversight. The media moved from speculation to analysis. Trump remained engaged rhetorically, but disengaged institutionally. The system had reached equilibrium. In that equilibrium, Trump's options were sharply limited. He could continue to criticize the process, reinforcing perceptions of conflict without effect. He could disengage, allowing the matter to fade without resolution. Or he could pursue legislative revision, a path requiring congressional cooperation that did not materialize. None of these options restored control. According to public reporting, this moment crystallized the broader lesson of the Epstein files episode. Political power is loud, but legal power is durable. Trump's miscalculation was not moral or factual. It was structural. He treated a legal process as an extension of political theater. The institution treated it as compliance. The climax, then, was quiet but decisive. The Epstein files did not expose new crimes or trigger new prosecutions. They exposed the boundary between narrative and law. And in that boundary, Trump's influence reached its limit. As the immediate controversy cooled, Trump attempted a familiar strategic pivot. According to public reporting, he began characterizing the Epstein file debate as repetitive, outdated, and driven by hostile media rather than substantive issues. This shift signaled a retreat from confrontation toward minimization, but the institutional environment did not cooperate. Once records enter the public domain through court-supervised release, they cannot be retracted or reframed by political declaration alone. Legal analysts noted that archival disclosures take on a life of their own. Journalists, historians, civil litigants, and advocacy groups continue to reference them long after political actors move on. Trump's attempt to close the chapter ran directly into that reality. Court filings show that multiple civil cases and document reviews referencing Epstein-related material remain active. These proceedings do not depend on Trump's engagement or consent. They advance according to judicial calendars and evidentiary standards. Trump's rhetorical disengagement did nothing to halt those processes. At the same time, DOJ officials emphasized that no new criminal investigations were opened as a result of the file release. This clarification was meant to cool speculation, but it also reinforced Trump's constrained position. Without new charges, he could not claim exoneration through closure. Without control over disclosure, he could not dictate timing. He was left managing perception rather than outcome. According to public reporting, this dynamic frustrated both Trump supporters and critics. Supporters expected decisive exposure of elites. Critics expected systemic reckoning. Neither occurred. The DOJ delivered procedural transparency, not political catharsis. That outcome satisfied legal requirements while disappointing maximalist expectations on all sides. Trump's narrative challenge deepened as commentators pointed out the asymmetry. The institution had done exactly what the law required. Trump had promised more. That gap became the story. His continued criticism of the DOJ risked reinforcing the perception that he misunderstood or misrepresented the law's scope. Importantly, the DOJ did not respond in kind. Officials avoided personalized rebuttals. They issued technical explanations. They referenced statutes and precedent. This restraint deprived Trump of a direct adversary. There was no dramatic clash, only administrative persistence. According to public reporting, this phase revealed the structural ceiling of Trump's influence. He could shape debate, but not procedure. He could question motives, but not mandates. The system absorbed his objections without altering course. As coverage shifted from controversy to analysis, the Epstein files became less about scandal and more about governance. They illustrated how institutions manage politically sensitive material under public scrutiny, and they highlighted how presidential authority dissipates once legal mechanisms engage. Trump's remaining space narrowed further. The files would continue circulating, courts would continue operating. The DOJ would continue complying. His options were limited to commentary and complaint, neither of which altered the underlying process. By early 2026, the contours of the Epstein file episode were clear. According to official documents and public reporting, the Department of Justice had met its statutory obligations as interpreted under federal law. Millions of pages were released. Redactions followed established legal standards. No new criminal charges emerged. The system concluded its role. For Donald Trump, the consequences were subtler but enduring. He remained publicly associated with a controversy he could neither accelerate nor resolve. His decision to frame transparency as a political promise collided with the legal reality that transparency is procedural, not performative. Once the law took effect, control shifted permanently. Trump's blind spot lay in overestimating narrative dominance. Political messaging could not override statutory interpretation. Institutional resistance was not ideological, it was structural. Courts and agencies responded to mandates, not moods. That distinction constrained Trump's leverage at every stage. According to public reporting, Trump's options narrowed to three. He could continue criticizing the DOJ, reinforcing perceptions of conflict. He could disengage, allowing the story to fade without resolution. Or he could attempt new legislation, a path requiring congressional cooperation that did not materialize. None of these options restored control. They merely managed exposure. The Epstein files remained part of the public record, immune to rhetorical closure. For Trump, the episode underscored a recurring pattern. Confrontations with institutions tend to end not in rupture, but in containment. The pressure war did not explode. It dissipated into procedure. And in that quiet resolution, the limits of presidential influence became visible.